Zoom. Okay.
Oh.
Now we're recording. Thank you for pointing that out.
Okay. Oh, thank you. So
Larry, then before you begin, since we're now recording, and thank you for pointing that out, I'm just for the purpose of the recording, I'm not gonna go through that whole introduction again, but I will just say to those of you who are going to be watching the recording, welcome. This is After Roe, an assessment presented by the George Washington University Paralegal Studies Program. I'm Professor Tony Marsh, the director of the program, and joining me today is Professor Larry Ross, who will now explain the basis for the decision in Dobbs versus Jackson. And Larry, maybe you could just repeat for the benefit of those watching the recording what the decision does and does not do.
Right. So as Professor Marsh had mentioned, the decision here does not outlaw abortion. It changes the status of the constitutional view of abortion under Roe versus Wade in 1973, and then later under the Casey decision. Those courts had pronounced that there was a guaranteed right to abortion, not absolute. There were always limitations to it. But this new decision that just came out, Dobbs, says that that was completely wrong. There is no constitutional right, and that the matter is actually better understood as a matter of state law. And at least as so far, the only restriction that they're placing on the ability of the states to regulate abortion is that a state law has to have a rational basis, which is the lowest form of scrutiny that the Supreme Court will apply to a state court, a state decision, state law. So in the Roe decision, the court had found in the 14th Amendment that amendment's reference to liberties, people's liberties being protected, extended to abortion. Now, the 14th Amendment, you may remember, is one of the Civil War amendments, the 13th, 14th, and 15th. And the 14th is where you get the idea that equality under law being applied nationwide, because the original Bill of Rights was a set of restrictions on the federal government only. And the 14th Amendment has been read to extend those rights and other constitutional protections more broadly and apply to the states. However, something changed with the Supreme Court in the last several years, namely its makeup. And there's now a majority of justices who have certain judicial philosophy. I will not try to put it within political terms, but rather within philosophical terms. They're so-called originalists who want to go back, who believe that you best understand the Constitution by looking at how the Constitution, the words of the Constitution, would have been understood at the time that each part of it was adopted. So what we'll see during assessment of Dobbs is that they keep looking back to the 1860s and focusing very much on what laws were in effect nationwide at that time.
Well, they look back even I have to interrupt for a minute. They look back a little further than the 1860s. They
do, and a little more recently for those states that came in later. The other thing that's changed is that there was a decision a couple years ago called Janus versus AFSCME. And it's a labor law decision, but it overturned a earlier Supreme Court decision, a Abood decision that had been on the books for decades, dealt with union law, labor unions. But it came from Justice Alito, and it sort of, I raised a flag at the time. It sort of pointed out that he was ready to not ignore, but to feel far less bound by the principle of stare decisis or stare decisis, depending how you want to pronounce it. And that's a principle that the court uses. It says basically we're going to stick with earlier decisions. We're not going to go changing the rules, based on how we feel from time to time. We're going to try to be consistent. But starting, like I said, I think Abood was really the signal that these older decisions were up for grabs based on the new makeup of the court.
So that's a really important point here. And so what, I want to just jump in quickly. So what the majority bases their opinion on here, and Larry, let's, maybe we could expand on this a little bit. So they go back and they say, we're looking at a couple of things here. We're looking at, let's look at Roe and Casey. Roe and Casey are based on substantive due process, right? Like Roe, let's start with Roe. Roe finds that under the 14th Amendment, we've got this right to due process, which has been interpreted over the years to include not just procedure, but also this greater body of substantive rights, including this right to liberty. And then, in that right to liberty, then the court has decided includes this right to privacy, this right to bodily autonomy, this right to make private personal decisions about your private personal life and your body, right? So that was the substantive due process issue, and the court looks at that. That's one of the things that the court examines. And I guess that's really what they base their decision on, right? So they go back to the 1600s, 1700s, 1800s, all times when women were not viewed as equal citizens, right? Let alone minorities, but let's just talk now because this is a women's issue. Women were not viewed as citizens at all, let alone equals. And they go there to determine what the framers, what the writers meant by due process, by liberty, by substantive due process, and they use that as their guide stone. Is that how you read it?
Yeah, I mean that's the basically almost a core principle of originalism, is that you have to go back to the time when the text was adopted, and they don't even look for what a legislature might have meant. It's only what would the general understanding have been. So yeah, they are going back there, and I know Justice Scalia would say that, well, if the Constitution's outdated, just amend it, which will more easily said than done. But yeah.
Right. And they do mention that in the concurrence. I think it's Kavanaugh talks about that and says, if you want to change things, there's ways to change these things, and it's not through judicial fiat. So they go back, and the first thing they do is they go way back. They jump in the way back machine and they look at what they meant. How they felt about abortion in the 1700s and 1600s. 1700s, 1800s, and the court finds, or the majority finds, that abortion was illegal at that time. And by the way, some people disagree with that assessment, including the dissent, but finds that it was illegal at that time, and therefore it's not a deeply rooted right. And let me back up for a minute. In determining whether substantive due process, whether a right is included in the substantive due process, what the court says is it's either got to be enumerated, so it's going to be written out in the Bill of Rights or written somewhere in the Constitution, or it's got to be deeply rooted in the nation's history and traditions, or an essential component of ordered liberty. And that's what sets them down this road of looking way back to the 1600s, 1700s, 1800s to see, is this deeply rooted in our nation's tradition and history? That's the first thing. And then they look at the laws and where it was legal, where it was not, to find out whether it is part of our essential to our concept of ordered liberty. Is that your reading, Larry?
Yeah, that's, I mean, basically it's, again, so enumerated means it's actually there written in the Constitution, right to bear firearms, for instance, freedom of religious exercise. But if it's unenumerated, if it's not spelled out, then yeah, they want it to be part of a historical record
Right.
of freedoms. And looking at abortion, the historical record shows otherwise.
Right. So then we look at, oh, go ahead.
No, I was going to say, which, yeah, there were laws all over the books in the mid 19th century saying that restricting, if not outright banning the practice of abortion.
Right. All right. So then we look at that. And I am jumping around a little bit in this PowerPoint, jumping back and forth a little bit because our conversation is kind of following, not following a straight line from A to B. But now the Roe court, before, the way that Roe got there again was they found this overall right to liberty, and they found this right to privacy, and they acknowledged that some people, and the Roe court and the Casey court acknowledged that many people believe that life begins at conception. They understand and acknowledge and honor, the fact that many people have deeply held personal, moral, religious beliefs about when life begins, and understanding that, and in light of that, they strike a balance, right? They strike a balance and they say, look, we get it. And so they protect the right to an abortion in Roe, for the first 2 trimesters, and then in Casey after viability, which comports with this historical analysis of abortion law that the court engages in, where historically, starting in the 1600s, legislatures, courts drew the line at what they call quickening, or when the fetus becomes perceptible by the woman, when the woman can perceive life in her womb. That's their cutoff point. That's historically been the cutoff point. So there's always been this cutoff point, or this balance, even in these ancient cases that the court looks at. So what do you think about that, Larry, about the way that the court sort of cherry picks its facts? Do you think that it engages in that? Like, it says, well, it was illegal, but they don't look at the fact that even then courts were drawing a line between viability and non-viability, or quickening and pre-quickening, things like that.
Yeah, and they actually, they do kind of address that. There were states where it was different. I of course, went straight to the section of the appendix that talked about Rhode Island. Anyone and my former students know that's where I always look, my home state. In Rhode Island, it was always just a misdemeanor. It was never a felony. And there are states where it's not a law until quickening, which is the term they used in prior centuries for when the life of the fetus was detectable. So a heartbeat or motion. But the court sort of does address that in saying that, well, yeah, maybe not every state had the same sort of strict laws. Some of them just said it's murder. Some had plans for quickening, some didn't. They said, well, but that's enough to show that it wasn't a universally held right. So even if it's just a misdemeanor, it's still not allowed.
Right.
Even
so
if okay.
Yeah, so let's talk a little bit, and you mentioned this, but let's a little more let's talk about stare decisis.
Right.
And let's talk about first of all the reasons, and I don't have it listed on this PowerPoint, so you'll have to go from memory, Larry, if you can, or I'll try to do it from memory. But the court cites 3 things that you consider, not the 5 factors, not these 5 factors, but the 3 reasons that we have stare decisis. Do you remember those? They give it, and one is for predictability, right? For predictability and consistency. One reason, I think I might be able to remember all 3 off the top of my head. One is consistency and predictability. The other is the actuality and perception of integrity. So that people looking at the way the court decides understand that the court decides as it does for a reason. It's not just, well, we feel like it, right? You can point to decisions that came before and say, well, no, this is based on this decision that we're reaching today has got basis, right? In precedent, it's based on precedent. So that's the other reason. And then the third reason is reliance, so that people know what the law is going to be, right? They can base their actions on what the law is because they can look at what it has, and as it exists. So those were the reasons that the court cites for why we have stare decisis, why we use precedent in our legal system. But then it goes on to say, but look, stare decisis, it's not permanent, it's not immutable. I think inexorable is the word they use. You can overturn precedent. This court can overturn precedent, and the majority and the concurrence cite that, Plessy v. Ferguson, which is, by the way, the same case that Justice Amy Coney Barrett cited during her confirmation hearings when she was questioned about precedent and said, well, certainly you can overturn a horrible law. Look at Plessy v. Ferguson. If we couldn't overturn precedent, we'd still be saddled with Plessy v. Ferguson. Plessy v. Ferguson is the case that said that separate but equal accommodations were constitutionally acceptable. And of course, the court overturned that in Brown v. Board of Education. So they use this really, commendable case, Brown v. Board of Education, overturning this horrid case, Plessy versus Ferguson, as their example for why the court is able to overturn precedent in some situations. And then they give these 5 factors. And Larry, maybe you could talk a little bit about how the court addresses these 5 factors in its opinion in Dobbs.
Yeah, well, basically I don't remember all of them very clearly because nature of their error and quality of their reasoning are disposed of in pretty short shrift, because
Exactly right.
They're essentially saying this, well, they didn't look at the history, they didn't, they made things up, so they just sort of easily say,
They
well,
just dispense
those factors,
right. They say they weren't just wrong, they were egregiously wrong. They were wrong from the start. They're so wrong. And, they kind of, it is sort of a self-fulfilling kind of a thing where he just says, it's wrong because it was so wrong.
Yeah. Workability, I don't remember what they even say.
So that was a really interesting one. So in workability, what they do with that, and it's kind of funny to watch the court at work on this, because they say, well, Casey says that an abortion regulation cannot impose an undue burden on the woman. And then they go all off, and in my notes, I wrote in all caps, what does that even mean? I mean, they get all, what do those words mean? Words, they're just words like undue. What does undue mean? What does due mean? What does undue mean? What's a burden? What's not a burden? And they go on to say, well, Casey says, an undue burden is a substantial obstacle. What does substantial mean? What does obstacle mean? They really sort of disingenuously suddenly start to not understand what words mean. Words that we have seen in the law many, many times. So it's interesting the way that they say, it's not workable. This is just not workable. We can't possibly know what all those complicated words like substantial and burden and obstacle mean. So that's how they dispose of that one. And then disruptive and reliance. What about that?
And the reliance is probably the most contentious of these 5, because they're sort of dismissive. They say, well, women don't go through their lives saying, oh, well, I can always get an abortion, that they don't conduct their lives based on that principle. But when you're also talking about there's also right now a sort of broader range of abilities that are being discussed. I mean, right. This is about abortion. Next, we'll talk next on the hit list will be contraception. And then, it's reliance. There's reliance on this body of legal entitlements.
Exactly.
And, you can't, get around that by just eroding them one bit at a time.
By just saying.
I mean, that's just my saying that, but they do say that, it's simply that no woman, lives her life on the principle that she can just get an abortion. That they make other choices, they have other options, and it's not anything that creates reliance.
That's exactly, So, and I'm going to come
there's
back.
a lot of dispute about that.
Yeah, you're exactly, I guess I don't have a slide on this one, but let's explore this a little bit, Larry. So, they under stare decisis, they just say, well, it's wrong because it's wrong. They say the substantive due process, there doesn't protect, this whole idea of bodily autonomy. We're going to look at what the people in the 1600s, 1700s, 1800s thought about this. They didn't recognize it, therefore we don't. So then what about this whole body of civil rights that is based on substantive due process? And I guess we get there. I guess I cover this when we get to the concurrences, and we can sort of jump ahead to that Thomas concurrence. You've got Griswold v. Connecticut, contraception. You've got Lawrence v. Texas, sexual relations, intimate sexual relations, and Obergefell v. Hodges, same-sex marriage, are all based on that concept of substantive due process. So, Larry, what does this mean for that?
Yeah, so substantive due process, well, perhaps it's easiest to say that due process gets used in two ways. There's procedural due process, which is that everybody is subject to the same legal process, and as long as you get all of your entitled hearings before the courts, that's fair. Substantive due process is a phrase that came out of Roe and in similar cases, with the idea that there are certain liberties that we enjoy primarily under the 14th Amendment, because of, that they're something that's necessary for our well-ordered society, for our ordered liberties. And that if you take those rights away from people, then you're undermining the country as a whole, the rule of law, democratic process. So substantive due process, as we've got Justice Thomas here up on the screen. In his concurrence, he declares substantive due process to be an oxymoron that lacks any basis in the Constitution. Attacking it as an oxymoron, as I was telling Tony, that doesn't hold much water. Jumbo shrimp is an oxymoron, but they do exist. So just the fact that the name is an oxymoron is not really an argument. But lacking any basis in the Constitution, well, that's the whole issue. If you assume that it lacks the basis in the Constitution, then you're begging the question.
And he specifically states, and these are these cases, and interestingly and glaringly mentions Griswold, Lawrence, and Obergefell, does not mention Loving v. Virginia, which is the case that constitutionally protected interracial marriage.
Now, Griswold.
Go ahead.
The Griswold is sort of predates Roe and supports, it was one of the decisions that was cited in Roe. Griswold struck down a law that tried to regulate people's rights to contraception. And Griswold said that, you have certain rights in your bedroom, and the state can't be there and tell you not to use contraception. Lawrence and Obergefell both deal with same-sex relationships. Lawrence v. Texas made it legal for people to have same-sex intercourse under the law. Obergefell is more recent, so most of you will remember that. That's the same-sex marriage. So Thomas is saying, even though the majority opinion says that we're not going there, Thomas is saying, let's go there.
Thomas is saying, let's go there.
Yeah.
Now, of course.
Now he does leave out Loving versus Virginia, which most of you I think will know is the Supreme Court decision that said that you can't outlaw interracial marriage. He leaves it out, and people are, there are people who say, well, that's because he's in an interracial marriage. But I think more of the point, when you look at Loving, you can find other justifications for Loving than substantive due process, because race is a suspect class, and suspect classifications are, even the originalists will say, are protected by the 14th Amendment.
Good point. And by the way, race is a protected class, and regulations or laws based on race, of course, are subject to strict scrutiny, the highest level of scrutiny, as opposed to rational basis, which now abortion regulations will be subject to, which is the lowest level of scrutiny. You mentioned that earlier, but I'm just, reminding our viewers of that.
Yes. And I am trying to be very even-handed and give every justice the benefit of the doubt, and assume that they have thought things through. So that's where you could look at Loving and find a justification outside of substantive due process. And Thomas also, in his concurrence, raises the possibility of looking for justification for those other unenumerated rights through the Privileges and Immunities Clause. And I'm not exactly sure what he's got up his sleeve there. But he is, at least if you take him at his word, trying to be open-minded about preserving some of these rights, just not through an appeal to substantive due process.
Good. And I mean, I do have to say, and you're right, you want to be open, even-handed here. And as we were discussing last night, I do sympathize with Justice Thomas in the whole business about substantive due process. What even is that? What does that even mean? It's always been a slippery notion and hard to define. And so I do get that. Well, so he says, it's time for us, he says something, he says, it's time for us to take these cases. We should reconsider these cases. We have a duty to correct the error established in those precedents. Of course, that whole discussion of stare decisis, setting up the idea that you can overturn bad law, even if it's precedential. But then comes the Kavanaugh concurrence. And what does the Kavanaugh concurrence do with respect to those precedents and those other civil rights that we were talking about, Larry?
Well, Kavanaugh, it's one of the things that Kavanaugh gets into here is that his concurrence is placed after Thomas's, and it's actually in many ways a response to it. He goes out of his way I'll just read the quote. To be clear then, the court's decision today does not outlaw abortion throughout the United States. On the contrary, the court's decision leaves the question of abortion open. First is the question of how this decision will affect other precedents involving such issues as contraception and marriage. In particular, the decisions in Griswold, Eisenstadt, Loving, and Obergefell. I emphasize what the court today states. Overruling Roe does not mean the overruling of those precedents and does not threaten or cast doubt on those precedents. So
he just directly contradicts.
Yeah. Well, it's not only that, but he's going out of his way to say that the court already said it. And now he's saying it again after Thomas comes forward. Right. The court says, we're not touching those. Thomas says, let's touch them. And then Kavanaugh says, wait, we said we're not touching them.
Yeah, let's leave those alone.
Yeah, I think
and he goes even further, can the state bar?
Yeah, I think that, it's telling that, his statement comes after that of Thomas.
It seems to be a calming. He seems to be trying to do some calming here, right? I said, trying to throw some oil on the water.
And he has of the newer justices, he has shown a tendency toward moderation, often leaning toward Chief Justice Roberts, who we'll talk about in a moment. He also
All
says,
right.
and just to make it clear, he also is trying to clarify some things, just boil down the majority opinion. It says that on the question of abortion, the Constitution is therefore neither pro-life nor pro-choice. He's trying to make it clear that we're just saying it's a state issue.
Exactly. He really does go out of his way to play it down, to say it's neutral. We are not outlawing abortion here. Can you bar people from traveling to other states to get abortions? I think no. Can we retroactively punish people who gave abortions? I think no. So he's very much trying to calm things down.
Yeah.
Then we've got the really interesting Roberts concurrence. So, and again, with Roberts, and anybody who's had me for con law or any class knows that I always talk about how Roberts is an incrementalist, how he is so concerned about the integrity of the court, maintaining the integrity of court, maintaining the legitimacy of the court. And to do that, he has always been loath to overstep anything. He decides things as narrowly as possible. So what happens here in Dobbs, where they were simply asked to look at a law that banned abortion after 15 weeks, in contravention of Casey's mandate that it just be after viability. They were simply asked to look at 15 weeks versus viability. And instead, the court overrules Casey and Roe, goes way beyond doing what they were even asked to do. Now, the court does proactively address some of those things in its majority opinion, but we don't need to get into those details right now. The point is, what does Roberts say about all of that?
Yeah, so I don't know if we made this clear at the beginning. The vote on whether the Mississippi law was constitutional was 6-3, but the structure of the opinions is 5-1 to 3.
So why don't you explain that? What do you mean by that?
Well, what I mean is that often you'll find that some justices will agree in part with the opinion of the majority, but then they'll write a concurrence where they express some slightly different take on things. He did not join with the opinion of the majority in any way. In fact, you have it on the slide here that he concludes his concurrence. It's concurrence only because he voted the same way. In terms of reasoning, it sounds like a dissent. When you write a concurrence or a dissent, you don't have to say any big flat statement at the end about how you're voting or anything. So at the end, he finishes with the line that you see at the bottom. I therefore concur only in the judgment.
Right.
He did not have to say that at all, but he goes out of his way to point out that he is not endorsing the reasoning of the majority.
The reasoning or even the overturning of Roe and Casey.
Yeah.
Right? Because we were simply asked to rule, we granted certiorari to decide one question, whether this Mississippi law overstepped the bounds of Casey by banning abortion at 15 weeks rather than pre-viability or post-viability. And then he says all that out of adherence to a simple yet fundamental principle of judicial restraint. If it is not necessary to decide more to dispose of a case, then it is necessary not to decide more. So he's quite unhappy with the breadth of the opinion.
Yeah, he's really citing there's a false dichotomy here.
Yeah.
And he says that it's another good quote from him is, both the court's opinion and the dissent display a relentless freedom from doubt on the legal issue that I cannot share.
That was a great line. I remember reading that and thinking the same thing.
Yeah,
if you're that sure, you're probably wrong. Right? The abortion, look, the elephant in the room. Abortion is a really controversial subject, right? Good people of good faith believe both ways, right? Good people of good faith believe that life begins at conception and that abortion is murder, and good people in good faith believe that women's rights, outweigh the right of the fetus, that it's merely a collection of cells, whatever. Good people in good faith differ wildly on this. It's not an easy issue. If you think it's an easy issue, you're wrong, right? You're not really giving it you're not giving it real thought. And I think that's what Roberts is saying here. So what about the dissent? Really interesting dissent by Breyer, Sotomayor, and Kagan. So the first interesting thing about it is that it's written by all three, rather than written by one and joined by the others. What do you think is the significance of that, Larry?
I keep thinking about what to read into that. I think it's, at first I thought it's, and this may be the most logical conclusion, is that it's a show of unity. That they aren't just, it isn't just one of them writing something and the other two signing on. That this is something they all contributed to. They've all added their voices to it. This could have been the grand farewell from Justice Breyer. They could have, handed it to him. But I think that they really all put their ideas into it, that it went around. And one of the reasons I think you can infer that is because it took so long for this to come out, even though we know from the leak that the majority opinion was pretty much in its final form back in February. So there was people were still working on this.
Right, there was almost no change between the two. So the dissent, I think, is interesting in the vehemence of its tone. I mean, they hold back not at all. As you pointed out yesterday, Larry, when we were talking about this, they use the word hypocrisy. That's a strong word to throw around, among colleagues. And this kind of thing, this may be what the justices were talking about. I know that Thomas has been talking about it, of all people, but the lack of the breakdown of camaraderie and respect among the justices for one another. They don't say we respectfully dissent, which is often what justices use the word. I respectfully dissent. There's no respectfully in this opinion. There's lots of snark. They talk about, balance and moderation. I don't think the majority know what those words mean, or they certainly don't understand those concepts. They don't hold back. They're angry. They're sorrowful. And they don't hold back. I think that's probably the most interesting. Another notable thing about the dissent is that, unlike the majority, they talk about the women. They talk about women's rights, women's feelings, what women are going through, the physical demands of pregnancy, the career demands, the social demands, the financial demands, the trauma of adoption. They talk about all of that. Yeah. The majority barely mentions that.
Well, and also in terms of, they take a dig at originalism along those lines as well. The passages, we referred there to the people who ratified the 14th Amendment. What rights did those people have in mind at the time? But of course, people did not ratify the 14th Amendment, men did.
That's right. And they precedes it by saying, and again, a little bit snarkier. Yeah. Oops, there was an error in that last. Did you notice there was an error in our last sentence?
Yeah, if women had done it, there might be a couple more enumerated rights.
Yeah. So the dissent holds back not at all. They're angry. And they certainly don't hold. And but speaking of the leak, and there's not much to say about the leak, right? Except what you've already said, Larry, and that is that there's been almost no change between the leaked opinion and the final. A couple of words here and there have changed.
Yeah. Which also means there was really no attempt to bring Roberts on board.
Right.
Opinions will often change as a result of trying to accommodate another justice, especially when you're seeking to build, if not unanimity, at least, a significant block of votes.
Yeah.
And it looks like they didn't really try.
Right. So that's all we really can say about the leak. Quickly, and I want to wrap this up because I see there's lots of questions in the chat and I'd like to get to those. The state of the states. So what you see here before you, and by the way, I will share these slides with you, so you don't have to worry about taking notes or anything like that. You'll get these slides, but they kind of go from darker to lighter. So the darkest red are states where abortion is already banned or effectively banned. A lot of those states had trigger laws in effect. That were, they had laws on the books. They either had old laws that were already on the books that they never repealed, but they didn't enforce in the face of Roe and Casey, that they're now enforcing, or they had laws that were designed to take effect immediately upon the issuance of Dobbs, or within a couple of days or a week or so. So, you know, you could see the states that where it's already banned. The slightly lighter red, Kentucky, Florida, Louisiana, and Utah have bans on the books, but they have been blocked by a court in their state. The next lighter red, Montana, Idaho, Wyoming, North Dakota, Nebraska, etc., expected to be banned very soon. Kansas, Virginia, North Carolina are states where it's currently legal, but doesn't look to be legal for long. Kansas, you know, Virginia, North Carolina are purple states right on the border of the North and South. So there's lots going on in those states where they're, you know, sort of going from conservative to liberal and back again. Kansas has a constitutional amendment protecting abortion, but the Kansas legislature is currently working actively to repeal that amendment. And then the blue states that you see here in blue are the states where it's legal and protected. And many of those states, just last night, as I was preparing this, California announced that they would not honor any extradition agreements, anybody seeking to extradite anybody for any abortion related crimes. So the states that you see in blue are states where it's pretty safe for now, unless a national ban is passed.
And this map is changing. I think I heard this morning the Florida block on their trigger law is going away.
Okay, so that's what I mean. That was the disclaimer that I said, and that might have been pre-recording. The disclaimer is this map was current as of yesterday. And as Larry just pointed, it may very well be different today, it'd be different tomorrow. But this is where we stand right now. But the law, as you might expect, changing fast. You know, California just got bluer, and you know they're not only protecting it, they're also a sanctuary state, and now they've announced that they'll refuse to extradite. So there are many states, Oregon, Washington, I believe, have set themselves up as sanctuary states where they will, you know, allow women to come there, and some states are even saying they'll help pay travel expenses. Of course, I know you've heard that many companies have announced that they will pay travel expenses for women who need to go beyond 50 miles to receive medical care, and they're including abortion in medical care. Now that raises a whole host of issues that I have no idea about. I know how they'll come out, but you know, can a company mandate that an insurance company pay for certain procedures? What if the company is, you know, headquartered in Texas, or you know, something like that? So there's going to be lots of questions that are raised, but as of now, as of today, you know, 12/51, that's where we stand. Mm-hmm. And just quickly, one more thing, and that is contraception and abortion medication. As of now, abortion medication is FDA approved. It is safe. It is effective. It is widely available. And so Merrick Garland, United States Attorney General Merrick Garland, has announced that the FDA has approved mifepristone, I get it wrong, mifepristone, that it is approved, it's been determined safe. And if any state tries to ban it on the basis of health or safety reasons, that the supremacy clause preemption theory, that federal law preempts state law, that those state bans will not stand. So as of now, those abortion medications, which by the way account currently, even before Dobbs, for more than 50% of abortions in the US are via medication. That medication can be prescribed via telehealth, and it can be shipped via the US mail. That's the federal stance. Contraception, Larry, what were you saying about you think IUDs are the first?
Yeah, so the next phase, of course, is going to be state laws that get challenged. Because at least we know there's a rational basis requirement. In terms of contraception being a target, Griswold being a target, my guess is that the first thing you're going to see is some state having coming up with a law about IUDs. Unlike other forms of contraception, the IUD works by preventing fertilized eggs from implanting in the uterus. So there's already fertilization that's taken place, whereas the others prevent fertilization. And there's going to be argument about, now there's going to be the argument about, well, when does life begin? Because the political forces that brought us Dobbs would love to have a decision saying life begins at conception.
Right.
In the Dobbs decision, incidentally, the word conception only comes up once in the majority opinion, where they just say that that's one end of the spectrum for people's opinions. They never talk about that. They use the term, interestingly, they use the term fetal life. And fetuses don't come about until according to Google, I'm not an expert, Google tells me that technically the fetus isn't there until about 8 weeks into the pregnancy. So there could be some cases coming up about that
right.
About their use of the term fetal life.
No, I mean, if we're going to, conception is conception. And so, it's a really good point that the IUD may be next. We have like 6 minutes left, so I want to get to some of the comments.
Let's get some comments.
Although we could talk all day about this. So let me see. So there's a lot of commentary here, which is really interesting. Somebody mentions it's the midwives who handled abortion and it was private. Let's see, are there questions here? Nothing in the Constitution.
Someone mentioned, referred to Justice Thomas as the quiet justice. He's not. He's quiet during oral arguments, or at least was under the old rules, but he has consistently written more concurrences and dissents than any other justice. When it comes to writing, he is beyond prolific.
Yeah. So yes, he has been quite prolific. And now that the court has changed its format, since they went telephonic, and they now go in order, he asks questions, he never passes, and he asks a lot of questions. So he's no longer quiet. So let's see, what consequences, because there's a lot of comments here that I'd love to, talk about, but let me just do the questions. What consequences for other thorny issues, right? The right to bear arms, same-sex voter suppression, should we expect based on this line of reasoning? Okay, so I think that we sort of addressed that. I think that now same-sex marriage is an unenumerated right, so I think it's vulnerable. Right to bear arms is an enumerated right, and as we saw, the court dove into the right to bear arms. Even in this opinion, they mentioned the right to bear arms and cite it as one of those rights that has been long protected as part of our history and tradition. And so the right to bear arms is not getting...
I'd say the most vulnerable of those decisions that they mentioned is going to be Lawrence v. Texas, which struck down laws outlawing same-sex intercourse and same-sex sexual activity, because when you look at it, you see the same body of ancient laws forbidding it.
Good point.
Facially, it's a lot like Roe.
Yeah, we can go back to the Bible on that one, right? So that would be certainly give us a body. How would the originalists account for medical advances? Well, so that's interesting. I mean, they don't, right? That's the whole point. And you said, quickening would take much longer to detect now than it took much longer in the 1860s than now. You're absolutely right about that. So
on the question of advances like that, there was a passage in the in the dissent that I really liked, because we talked about originalism at the beginning. The justices in the dissent follow a different philosophy called the living constitution. And there's a paragraph in the dissent, short paragraph, I'll just read. The framers, both in 1788 and 1868, so that's the Reconstruction Amendments, understood that the world changes. So they did not define rights by reference to the specific practices existing at the time. Instead, the framers defined rights in general terms to permit future evolution of their scope and meaning. And over the course of our history, this court has taken up the framers' invitation. It has kept true to the framers' principles by applying them in new ways, responsive to new societal understandings and conditions. So that's, in a nutshell, the philosophical divide that's present in Dobbs, and that for years was leaned in favor of the living constitution philosophy. And now we've got a 6-3 or at least 5-4 originalist originalist allotment on the court.
Well, that is fabulous. And on that really brilliant final note, I think this is a great place to stop. We could talk for hours, but we are at 1 o'clock. And, you know, that quote from John Marshall and the framers about the living constitution versus Scalia's dead constitution, right? And his mentee, Amy Coney Barrett, you know, certainly is carrying forward that tradition. So thank you to Larry Ross for a great conversation. Thanks to everybody who joined us. Great to see Professor Fullard here and Professor Lisa Liebau here. And forgive me if I missed anybody else. I can't see the whole list of participants right now, but it's been Professor Elliott here. Just wonderful to have you all here. Thank you so much. I will share this recording with you. I will share the slides with you. If you are not a GW Paralegal Studies student or alum and you're interested in learning more, there will be a slide in there that gives you my name and address and email. If you'd like to learn more about paralegal studies and talk about this kind of stuff all the time, we'd love to have you. So thank you, everyone, and goodbye. Look forward to seeing you all very, very soon.